First of all, just to introduce myself, my name is Rajesh Sagar. I'm a managing associate at Marks & Clark Solicitors in London. I'm a patent litigator who's dual qualified in the UK as well as in India. Most of my work comprises advising clients on patent issues in TMT, pharma, biotech sector, including advising clients on SEP and FRAND issues. In relation to the Unwired Planet case, we have heard about it, and most of the times what I've heard from at least the Indian clients as well as Indian audiences, it's a very controversial decision. And one of the biggest objections being raised is, well, actually, you know what, how could a UK court decide on a global FRAND license? And in fact, one of the famous IP blogs went on to the extent of saying that the UK courts still suffer from historical imperial attitude. It's really controversial statement. I think I'll try to address some of the controversies being raised and some of the issues that has been mentioned to me in this presentation. I think some of the criticism that is being levied is unfair. In fact, most of the criticism, because the decision is very, very reasoned, well-reasoned decision in my opinion. In fact, the Court of Appeal has also agreed, if not all, barring one issue, it has agreed with everything what the trial court has said. In fact, all of the other jurisdictions in Europe have also stated that it is actually a good decision. But as I said, for me saying here it's a good decision doesn't help anybody, except I have to sort of go through the decision, explain some of the fundamental principles that the court has set out in this decision. In terms of my presentation, I would be covering some of the main strands. I will be talking about the Unwired Planet versus Huawei case. It's a first instance decision where I would be briefly touching about how the court has determined the FRAND terms and the FRAND royalty rate. Then the court also devised a unique remedy to deal with the standard essential patents and has been termed as FRAND injunction. Secondly, I will be talking about the Unwired Planet versus Huawei, the Court of Appeal decision, because Huawei went in appeal in relation to 3 issues and see what the Court of Appeal said about that. Afterwards, I would be looking at some of the recent cases. I'm very conscious this is basically a graveyard slot. I'm standing between the end of the day and coffee and dinner. And also we are running short of time. So maybe I would just mention those cases and leave at that. So essentially one of the cases deals with, do we want to have the technical trial first, i.e., do we have to always determine validity and infringement of a particular standard essential patents and then deal with the FRAND issues, what the royalty rates are? In TQ Delta Xiaxel case, the courts have expressed an opinion that actually we don't need to do that. It really depends on the parties. We need to be flexible in this case. So again, I'm just mentioning it now in case I do not get an opportunity to mention that later. The second issue is, of course, confidentiality. Most of the time, once you are in litigation, one of the ways of looking at how to determine royalty rates, one of the approaches which Aishwarya did point out is the aggregate royalty burden, top-down or top approach. Now, in those, one of the cases when you're looking at is the comparable licenses. And of course, defendant or the claimant has entered into a number of agreements. Those agreements have got confidentiality terms within themselves. Now, these is to be disclosed to a party to a litigation. How do you preserve the confidentiality of it? Again, this issue was touched in TQ Delta Xiaxel case as well. Again, I've got some slides, but I'll touch on that later on. Otherwise, afterwards, we have coffee sessions. Please feel free to ask me questions if I'm not able to touch on that. So moving on to before the Unwired Planet case, Huawei versus ZTE case, I just want to briefly touch upon that. Of course, this case was a seminal case that sets out the principles of how the potential licensor and potential licensee should behave in terms of the FRAND negotiations in relation to standard essential patents. I'm not going to touch upon in detail because I believe most of you, if not all, are already aware of those. However, I would point out 2 further reflections that the CJAU mentioned in this case. The first one was, he says, where the counter offer is rejected, the parties may agree without delay that the FRAND royalty rate should be determined by an independent party. Now, the criticism that is being levied at the UK court is, how can they determine global FRAND rate for a party that is when the case only involves UK patents? In this case, Huawei went into the court, accepted court's jurisdiction when Unwired Planet filed its case and asked the court to determine a FRAND royalty rate. So the court was asked to determine what is FRAND royalty rate, what is a FRAND license. The court looked at the evidence and decided, actually, in this particular case, on the basis of the facts that are before me, it is a global license, should be a FRAND license. And what's the objection here? What's the controversy here? Two parties, an implementer and SAP owner, both went to the court. The implementer accepted court's jurisdiction. In other words, they were saying, hey court, UK court, you are an independent party, decide what's FRAND royalty rate. So I don't see personally, I struggled with the decision initially, but having two parties accepted the court's jurisdiction and the court deciding the issue, then the only remedy that's available to the party is to challenge the basis on which the decision whether it is a FRAND license or not, a global license or versus a national license, you have got that. That is the only justiciable issue that is left. Next point is essentially is where the CJU also held that just because the parties are negotiating a FRAND license or undertaking further negotiations, talking about taking a license, etc., does not mean that the alleged infringer cannot challenge the validity of the patents. They are free to do so. Anyways, moving on from these principles is Unwired Planet, Huawei, Samsung, Google case. In this case, Unwired Planet, I'm not going to go deeply into the facts. Essentially, Unwired Planet had obtained certain set of patents from Ericsson, and then they tried to enforce these patents against a number of phone manufacturers. They filed an infringement action, number of correspondence letters were exchanged, number of offers being made by Unwired Planet to these parties. These parties had made counter-offers, and of course, nothing happened, no license terms were agreed, infringement action was filed, and of course, in the action, the relief that was sought was an injunction as well as damages, as is normally the case. Then, of course, after the trial, certain patents were held valid and essential. Then the court had to decide on the non-technical issues, what are the FRAND royalty terms? And also, it had to decide some of the defenses, we call them Euro defenses in Europe, whether actually Unwired Planet had abused its dominant position by not following the approach of Huawei ZTE case of the Court of Justice of European Union. It also had to decide whether the circumstances merit issuing an injunction, because, of course, given Huawei is saying that Unwired Planet had not followed the prescribed approach. So, what are the main points arising from this decision? The first point was the court held that, of course, when a FRAND undertaking is being given, one of the issues was, is it enforceable? Can an implementer force a SEP holder to grant licenses on fair, reasonable, and non-discriminatory basis? Now, again, this is one of the issues that I posed while talking to people was, the concept of FRAND, which law does govern it? Now, at least in relation to the cellular technology, the ETSI policy, European Telecommunication Standards Institute policy, is governed by French law. And all the FRAND undertakings and what FRAND is, what essentiality is, once again governed by French law. So the concept of what is fair, what is reasonable, and non-discriminatory is generally construed under French law, although this issue wasn't decided by the judge because none of the parties took that issue in the UK. But anyways, the issue that arose before the judge was the FRAND terms and this undertaking, is it enforceable? And the court looked at the expert evidence on French law from both sides and decided, yes, you can enforce FRAND undertaking an implementer who can take advantage of that undertaking. It can be enforced. Although it wasn't a clear-cut question, but the court did decide that. The question arises, well, you can enforce a FRAND undertaking, but can you force a party to grant a license? Now, on that question, of course, the court said, we cannot force a party to grant a FRAND license. Now, you would be thinking, if you can't force it, then what's the remedy for an implementer? Would they be injuncted? The answer to that is no. The court clearly said where an entity that has given its FRAND undertaking and then refuses to license its patents on FRAND basis, what we can do is we would refuse to enforce its patent in the jurisdiction. In other words, in the UK, that entity would not be entitled to get an injunction or damages in relation to patents that are subjected to FRAND undertaking. That's how the balance is created. Moving on, the next question is, again, the court said it has not only jurisdiction to assess whether any offers or counter-offers were made by a party were FRAND, but it could also determine what FRAND rate is. Again, it was based on some of the issues that the parties had raised, the cases they had filed, and the jurisdiction that they had agreed before the court. This issue is slightly controversial, where the trial court had held there is a single FRAND royalty rate that is applicable. So you can only have one FRAND rate. It is not a range. And I will touch upon this when I look at the Court of Appeal decision in a second, because this was the only point where Court of Appeal had overruled the first instance judge. Again, there was an issue about non-discriminatory. What Huawei was agreeing is that when Unwired Planet or any SAP holder issues favorable terms to one licensee, then the same terms should be given to all other similarly placed licensees. In other words, there's a hard-edged non-discrimination. The court rejected that notion. Court said no. They brought in the concept of competition law, and they said, yes, the terms can be different, provided they do not place a party at a competitive disadvantage. Court also said that the initial framework provided by Huawei versus ZTE is actually not a mandatory. It is basically a safe harbor. There are a couple of other main points. Again, I'm conscious that we are running out of time, so please, if you think I should stop at any stage, do let me know.
5 minutes.
5 minutes. Okay. So FRAND licenses, again, court looked at should a FRAND license in this case should be a global FRAND license or not? And again, court said a global FRAND license is not mandatory or in all cases. However, in this particular case, let's look at the evidence. The evidence was what? Look at the standard comparable licenses that have been executed between implementers and other SAP holders. They were all global licenses. Look at the scale of operations of the parties. Huawei, you're operating all over the world. Unwired Planet, your patent families are all over the world. So, given these circumstances, the court said, in this case, in this particular case, the license should be a global license. It's not saying that every circumstance, the court didn't say in every circumstances, the license should be a global license. It has to be determined on the basis of the fact and evidence before the court. Again, court also said that FRAND does not characterize only the terms of the license. It also characterizes how the party is behaving during the negotiations of setting up a FRAND license. Again, it's quite important because it is taking into account some of the conditions that are being held by the Huawei ZTE case by the CJEU. Again, non-discrimination part, as I said earlier, there were some of the things the court looked at. FRAND royalty rate must be set based on the value of the license patent and not on the size or other characteristics of the licensee. In other words, it should be independent of the licensee's position. And again, as I said earlier, that the party or the SAP holder is entitled to grant different FRAND royalty terms to different licensees, even though they are similarly placed, provided it does not put them at competitive disadvantage. Just very briefly, how do you calculate FRAND royalty rates? Again, the court had looked at the comparables. As I said before, Unwired Planet had acquired a percentage of Ericsson's portfolio. Court had comparable licenses that Ericsson had negotiated with other technology implementers. It looked at, okay, this is Ericsson's rate X. Unwired Planet, you have got S percentage, Y percentage of entire Ericsson's portfolio. So the simple case is, royalty rate charged by Ericsson should be relative strength multiplied by relative strength of Unwired Planet's portfolio. So that was the comparables approach. And that was the preferred approach of court, primarily because it says it does take into account the industry-wide practice. Then, however, in order to just confirm what the royalty rate the court was arriving at, it also looked at the top-down approach. And a top-down approach is also called as aggregate royalty burden. What they looked at was, what is the total royalty burden of a particular standard on a product? So they looked at, Ericsson had made certain statements, oh, it's 6 to 8% of a mobile phone, that should be the aggregate royalty burden. So in this case, there were statements being made available, expert evidence was given on the issue, and then the court went on to calculate what is the patentee's share of relevant SAP's S. And that's where Aishwarya had told us about different methodologies, how to calculate the relative share of a particular patentee in the entire patent portfolio that's relevant, or the patents that are relevant for a particular standard. And then the court went on to multiply T and S in order to come into a particular royalty rate that should be payable on those patents. Again, I'm not going to very quickly mention this. These are not that important. Just FRAND injunction very quickly. I would mention what sort of final injunction is available. That's very much similar to the India, and why Unwired Planet, where we were slightly different, and of course, what is a FRAND injunction? Very, very quickly. Final injunctions, as we know, and injunctions are a discretionary relief. You don't get it as a matter of right. It is a discretion of the court. Once granted, it prohibits the defendant from undertaking infringing activities for the life of the patent. And lastly, you can't come back to the court to vary the order once a final injunction is granted, even if certain circumstances change. However, Unwired Planet, why it wasn't a usual patent case? Of course, there were certain patents which were standard essential patents. These patents were also subject to FRAND undertakings. In other words, the situation was slightly similar to, as I always say, is licenses of rights. You've got patents that are endorsed with licenses of rights, sort of similar situation there. And again, the court had determined the FRAND royalty rates after it had found Unwired Planet's standard essential patents valid and infringe. And what if now a party is refusing to take a license? So what the court said, it basically, again, I said the court had determined a license. Moving on, just very quickly, a FRAND injunction is an injunction. What the court said, it would automatically cease to have an effect once the defendant entered into a FRAND license as determined by the court. It also said where a FRAND license is shorter than the duration of an SAP, each party is at liberty to come back to the court and ask the court to vary the injunction, either revive the injunction or vary the terms of the license that has been entered into. Now, that is quite important if the parties were going to come back to the court. The court will consider how the parties have behaved in terms of negotiations of reviving the injunction or not. So that's, I will just stop there. And of course, once FRAND injunction is, again, it is, party has the liberty to apply if the FRAND license ceases to have effect for any reason. And this is one of the issues that has been discussed, where the standards do keep on changing. Patents are basically opposed and held invalid. In other words, you would have a liberty. It's not that the FRAND terms are set in stone. You have the opportunity to go back to the court, to the UK court, and talk about it. I think with that, I'll just stop there.
Yeah, thank you so much. Very, very clear. Better to say it is a good contribution to what we have